Good afternoon, everybody. My name is Melanie Escher with the Arizona Telemedicine Program and the Southwest Telehealth Resource Center, and I'm here with Tara Sklar and some of our presenters, which we will get introduced in momentarily. And you have joined us for Navigating the Digital Health Legal Landscape, User Guide to State Data Privacy Laws. We respectfully acknowledge the University of Arizona is on the land and territories of Indigenous peoples. Today, Arizona is home to 22 federally recognized tribes, with Tucson being home to the O'odham and the Yaqui. The Southwest Telehealth Resource Center represents the states of Colorado, Arizona, New Mexico, Nevada, and the Four Corners region, with a combined total of 72 recognized tribes. The university strives to build sustainable relationships with sovereign Native nations and Indigenous communities through education offerings, partnerships, and community service. Welcome, everyone. Next slide. So as you join today, your phone or your computer microphone were muted. Time will be reserved during and at the end for questions and answers. Please use that chat function for questions. We also have a post-webinar evaluation that will populate in a screen behind this Zoom link. The webinar is also being recorded and will be posted on our website later this afternoon. I will also be sending out a thank you email to everybody that has joined us today with a lot of this information, the link to the evaluation, and other information for getting your CLE credits or just certificates of participation. So the next slide, and without any further ado, I'm going to pass the mic over to our moderator, Tara Sklar. Tara?
Great. Hi, everyone. A very big welcome to you, and thank you, Melanie, for this great introduction. So we have about 108 folks that registered, and about a third of you all are lawyers in this space. So we are hopeful that we'll give you some really good information about what's currently happening and things to maybe prepare for going forward. I do want to give a special shout out to our sponsors of this event, including the Arizona Telemedicine Program and Southwest Telehealth Resource Center. We also really appreciate and value working with ASHA, the Arizona Society for Healthcare Attorneys, the health law program I oversee at James E. Rogers College of Law, particularly our Health Information Privacy, Data Security, and Compliance Certificate, and also Tech Law, another program out of the University of Arizona at James E. Rogers College of Law. So we had a lot of people involved in what we hope will be a very informative webinar for you today. And we are offering CLE, as Melanie mentioned. There'll be more information on that following the webinar, where you can get a certificate of attendance if that is something that you're interested in doing. And as Melanie mentioned, we also will share the PowerPoint slide deck and the webinar recording in case there's anything you'd like to go back to or to refer to any of your contacts. So in terms of our flow, we're trying something a bit new today, where rather than have one of our really phenomenal and generous panelists present, and the next one presents, and then at the very end we have Q&A, we thought we'd do a bit more of a hybrid approach where just so we're all kind of having a similar foundation of what to expect in this space, each one of our presenters will present a few slides, then I'm going to stop the PowerPoint screen share and we'll have more of a roundtable. And during that time, I really encourage you to access the chat. If you have any questions, I'll be looking at it the entire time. If we don't get to your question then and there, maybe we can at the end. And then if not at the end, maybe we could do so following the webinar. So just to let you know, you are a valued participant throughout the next hour and to chime in at any time. The other thing in terms of the flow is we're really going to start from the federal level, what's happening in the space in terms of data privacy, then down to the very fast moving shifts that are happening at the state level, which Chase will help us dive into. And then Claudia at the very end will begin talking about, particular implications to think about, especially for digital health companies, providers, and patients going forward, given these shifts that we're seeing in this space. Last thing I just wanted to mention was that we have been talking about doing this webinar for quite some time, and I think now more than ever it's vital to address these issues, and that because so much is happening from us valuing the opportunity to have flexible access to digital health in our healthcare, but also a lot of concerns with breaches, commercialization, more prevalent AI in the space, and how it's being regulated with so much variation that I think it's really, really timely that we not only have this webinar, but potentially future ones where we take some deeper dives into this topic. So I'm going to briefly introduce each of our panelists and then turn it over to John Howard to kick us off. Um, but I just want to say that both John Howard and Chase Millay teach into our health information privacy and data security compliance program. And they're just absolute experts in this area. John, as you may know, if you're coming from us from the University of Arizona, he was for a long time the HIPAA guru on campus. Now he's a senior attorney at Clark Hill. He's a passionate advocate and legal advisor for organizations ranging from local startups to Fortune 100 companies. He has extensive experience in regulatory compliance and program building. And he also is certified as an information privacy professional and a certified information privacy manager. After John, we'll have Chase Millay come speak, who's an attorney at KO Law in Denver, Colorado. He assists clients in navigating the complex regulatory landscape around new technologies, particularly an emphasis on data privacy security and AI. And he advises not only on HIPAA and also the GDPR, the European General Data Protection Regulation, as well as what's happening at the state level. And then lastly, we'll have Claudia Stedman, an attorney at Snell and Wilmer. And her practice primarily focuses on broadly healthcare compliance, regulatory matters, everything from Medicare and Medicaid billing and coding, fraud and waste, and a lot more focus going forward now, I think, on telehealth licensing and compliance. So each of our presenters will talk more about their own interests and background in this space, but I just wanted to give you a nice broad swoop of where we are, where we're coming from, what we're going to be talking about. So with that, I'll turn it over to John Howard.
All right. It's nice to be here, and I'm glad everyone was joining. It looks like we've got a good turnout. After all the wonderful things Tara said, I mean, I'm John Howard. I've been working in information technology for probably 10, 15 years, if not longer. It's been a passion since I was very young. But then I moved from information technology into the legal and regulatory field and have worked in compliance in that area for a very long time. HIPAA itself has been something, as Tara said, that I've been working in for longer than I'd like to admit, to be honest. But it is an area of passion because I think it's very important that all the health information that all of our covered entities, our healthcare providers, health insurers, clearinghouses, and all those types of folks are protecting the information so we still have a valuable and respected health system. I always tell my clients and try and remind everybody that every data point that we're talking about here today is actually an individual. And so it's important to understand that these regulations aren't just to be onerous on healthcare providers, but it is actually very important so we can make sure that those individuals feel protected and can, feel free to use healthcare safely. The first thing I want to kind of go over here is just some level set, some background information regarding HIPAA. Sometimes there's a misunderstanding about the purpose and scope of the regulation. When it was first, enacted back in 1996, the purpose of it was to try and provide some synchronicity and some congruence, I guess, across the health industry across the United States. And that's why it's actually the Health Insurance Portability and Accountability Act. Privacy is in there. It's not part of the title. And you can see here that we've got the three main rules under HIPAA, which is the privacy rule, security rule, and breach notification rule. And they were slowly rolled out after the actual enactment of the law. And it was something that it took a long time to build the regulations to do. And the regulations, if you're in this area and you're familiar with HIPAA at all, they're expansive. We've got a lot of different rules that were created in there, implementation, like specifications and standards and the like, and actually all three of those rules mentioned. For the scope, it's important to understand that the law actually only applies to a very narrow section of health information. One, you have to be a covered entity, right? Like I mentioned, the healthcare providers, the health insurers, or the healthcare clearinghouses. But the information, it narrows down from, you get the Social Security Act broad definition of health information, and then it narrows it down from that to something that's individually identifiable health information, where it's actually information that is identifiable to an individual and actually has to do with their past, present, or future provision of healthcare or the payment of healthcare. But then you narrow it down further, and it's only for those covered entities that I mentioned. So there's a lot of health information, especially in our digital environment now, that actually isn't covered by HIPAA. And there seems to be a lot of misunderstanding from that, from consumer level all the way up to the legal level. And I know we've got several JDs on the call. And there's a lot of times in my practice, I'll actually get calls from other attorneys and say, hey, is this HIPAA or is this not? And so we have to kind of work through that to see if it's actually applicable. And so that becomes a big area of concern, especially when we're dealing with some of our digital health companies and providers. There's a lot of consumer health information that isn't protected, and that's where the states are trying to get involved. The federal regs also have tried, or the federal agencies have also tried to find a way to get involved in protecting that consumer health information. One of the big agencies that does it is the FTC through the health breach notification rules. And then also they try and regulate the collection and use of that consumer health information that's not covered by HIPAA through different types of regulations. One of the big areas where they try and rely on is, I think it's Section 5 of the FTC Act, where they try and get companies to make sure that they're being transparent about how they're collecting and using this information, and if they're not, then they go after them as a deceptive trade practice. So there are different ways and different laws that the federal agencies are trying to get involved. Can we get the next slide there?
That,
Yeah, yeah. Yep, thank you.
oh, sorry,
No.
let's go back. All right, that one?
There you go. Yep, appreciate it. So that's the other thing that we need to know about HIPAA is there's this idea of the state law preemption. So HIPAA actually preempts any state laws or regulations that don't provide the same level of protection to the protected health information that HIPAA is, designed to cover. So of course, again, we're narrow in the application of what's considered PHI and under the protection of HIPAA. But if a state tries to regulate in that area and their regulations aren't as stringent, then they're going to be preempted. And preempted means that HIPAA is going to be considered to be over and above. So it is going to be the law that applies. There are some exceptions, which I've got listed here, and most of those are going to be in the kind of like the public health space, whether we're reporting disease, injury, child abuse, and those types of things, or that the state is actually trying to audit and monitor and the reporting of such activities, or just auditing and monitoring the actual physicians that are acting. So like the medical boards and things like that have a right to audit, and then they can lay in laws and regulations over that type of data and activity. And then of course, that's to prevent fraud and abuse. But in general, if the state doesn't have a more stringent law, then HIPAA is going to preempt that law. There are some states where they do enact regulations and laws that are more stringent, and that's where we get a little bit of a complicated situation, right? Because everyone's trying to understand, one, how HIPAA applies, and then they have to figure out, well, is that law actually more stringent or not? And in what sense is it going to apply? Because it's often limited in the application as well. So again, it's all clear as mud, I'm sure. And this is all something that we've all been dealing with for many years now, trying to figure out how are we protecting this information? How does HIPAA apply? Where do the states come in? And what's going on there? Can we get to the next slide, please? Thank you. And so in that sense, I mean, we've got a lot of activity in the past, I'd say year and a half, where these gaps in this idea of how to actually effectively protect health information is going to kind of play out. There's been one of the big things that came out recently was the notice of proposed rulemaking from HHS OCR to update the security rule. That takes into account all the new technologies that we've had over the past, 5, 6 years, decade, and tries to implement new rules and adjust the security rule in a way where we can actually apply it and more effectively protect the information. The security rule in HIPAA in general was designed to be super flexible, so it would apply easily to entities of any size, right? Depending on their sophistication and scope of operations. Some of that flexibility is actually proposed to be removed from the security rule, removing some of the addressable or the required implementation specifications, and just making everything required. So that way, entities can no longer try and find a loophole or skate by and not kind of apply the security rules requirements. But at the same time, HHS OCR has come through and said, well, we think it's appropriate now because there's so many solutions and so many options and so many tools available on the market that flexibility still exists. We don't have to have it written into the rule. We'll see how that goes and if it makes it through the stages to actually become enacted and the rule of the law of the land. But that's what they're trying to do. They're trying to find a way to get in there and tighten this up a little bit, and that's one of the ways they're doing it. Another way that they've gone and tried to be more protective in certain areas is with the reproductive healthcare privacy rule. It's, of course, currently being challenged in the courts, and we've seen some successful challenges, specifically coming out of Texas, on the ways that HHS OCR is trying to interpret and change the regulations under their statutory authority. And that's part of the concern here, is whether or not they're exceeding their statutory authority and making these changes and doing it under their actual guides that they're allowed to operate under. The reproductive healthcare privacy rule was designed to try and protect just that, the reproductive health information of women when they're out trying to get care. It was, as we all know, a reaction to some of the rulings of the Supreme Court, but we're going to have to see how that plays out. It's just another way how HHS OCR is actually trying to find ways to keep requirement. Another way that they try to do so is through some of the website tracking technologies and their enforcement guidance that they actually put out. They didn't change the rules, but they were announcing how they were going to interpret them. Under that situation, the guidance essentially stated that IIHI, the individually identifiable health information, which is a level right above PHI, because it's not necessarily associated with the covered entities directly, was going to be considered to have the same protections as PHI. And so any information that was being collected through website tracking technologies on covered entities' websites was going to be afforded the same protections. And in entities that weren't protecting that information according to the security rule, the privacy rule, having appropriate contracts like business associate agreements and things in place with the companies that are helping them provide that technology, they were going to be considered to be in breach. That was challenged in the courts, the district courts in the Northern District of Texas. And they actually vacated the guidance, and they decided that OCR had actually overstepped its boundaries and had acted in a way and provided guidance that acted as law, and it wasn't law, so it didn't go through the rulemaking process. And then they said that they overstepped their authority. OCR decided.
John, are you frozen? Chase, can you hear me? Okay. All right, I'll stop sharing for a second. And John is he is actually coming in from Mexico, so he was having some power issues. So we'll see if he hops back on. 1 second. I think he might have faded. Okay. All right. Maybe we'll pivot just a little bit until John makes his way back. I really do encourage you to use the chat. Melanie, I may ask you to help monitor that as well, because when I do the screen share, I have a hard time seeing it. But maybe I'll just do like a kind of like a broader question to both Claudia and Chase while they're on, because I know they're both very familiar with HIPAA as well. This is like a nice segue, I think, into, oh, there he is, into what you're about to talk about, Chase. Hey, John, I was just explaining to our audience that you're coming to us from Mexico.
Yeah, apologies, trying to deal with the lost power at the house. And so we're trying to work through this in the best way possible. Okay, just jump back in.
Yeah, sure. Do you need to see the slides again, or do you want to just pick up with the tracking?
Yeah,
Okay,
no.
go ahead.
Yeah. Yeah, so essentially it's just with the tracking technologies, and we're seeing it in a lot of the digital health space. It's just another thing to keep an eye on. The federal agencies are trying to figure out how to address some of this. There is collaboration between FTC and OCR, and some of the other agencies in trying to figure out how to address some of these challenges.
No, I think that's great. I mean, those notable activities that you've highlighted at the end there, I think are where all of us really are right now with well, what is happening with HIPAA in this space. And when I might just but just 2 points to touch on real quick. And again, please feel free to use the chat to our audience members. So when we talked about the proposed security rule and how that was going to be a way in which to tighten up HIPAA, which I believe was initially enacted in 1997 to make it more current with what's actually happening now with digital health and the data space. So aside from like what's being proposed in that rule or maybe certain components of it, do you think that's in a way that HIPAA could still be, very relevant to the law of the land with what's happening with data privacy, or what are your thoughts on that?
Yeah, no, I think HIPAA is definitely still relevant, and it was drafted in a way to be very broad. And I think that's one of the things that we're seeing through some of the investigations that I'm helping clients through, is that OCR is applying it broadly, and that they're looking at it in ways to try and figure out how to protect all the information. Also, that they've made it clear that they're going to continue to work in collaboration with the other agencies like the FTC, and then also the National Institute of Standards and Technology and things like that, to try and address AI and things like that. So I do think it remains relevant. I mean, it's going to apply. The privacy rules are the privacy rules. You have to protect the information, right? The security rule, and the reason they're trying to change that is because, well, now that information is being managed and transmitted and collected in many different ways that the rule didn't originally anticipate. So that those changes are going to try and help tighten up on that. Yeah, absolutely.
Great. Chase and Claudia, if you want to chime in, feel free.
Yeah, I just think the only thing I would add, I think, as we'll talk about more about the kind of state consumer privacy laws, you do see a lot of conceptual parallels, these kind of concepts in California, for example, of a covered business and having certain technical and organizational controls. And so I do think HIPAA as this kind of privacy and security rule, yes, it applies to health information exclusively, but a lot of Americans kind of understand what it is. And I think it really informs, as drafters of legislation kind of think about the way they're going to structure things. I think it will continue to kind of form that guidance for even consumer privacy laws, because it's just something we get where it's like there's a privacy rule because you need to protect privacy and there's got to be security, and so I think that those fundamentals kind of will always persist, or at least in the near and midterm.
Great. Well, oh, go ahead, Claudia.
I was just going to add that I think you're seeing that with other pieces of federal legislation as well. Obviously, the ones that John mentioned, but there's sort of more effort to have overlap with HIPAA and like some of the information blocking rules, the 42 CFR Part 2 rules that have come out. And I think that as we saw this with COVID, obviously with telehealth, which I know we'll talk more about later, but I think we are seeing that too with AI and use of AI in medicine. And like every piece of legislation on a federal level, sometimes there's this lag component where new technology comes out and then the legislation has to catch up to it. But as John mentioned, HIPAA is, written very broadly. And I think that there are a lot of flexibilities with how you apply legislation that, came into effect at a time when we didn't have any of this, that's still very relevant and applicable and important to have. I think even more so now that more of this delivery is happening via technology rather than in person.
Great.
Yeah,
Go ahead.
And to add on to that, I mean, honestly, HIPAA is looked at as the gold standard across the world in a lot of ways. I've had clients from the Middle East reach out and say, hey, how do we be HIPAA compliant? And I'm like, well, let's talk about it. You don't really have to be. They're like, well, we want to be anyway, because that's the standard that everyone really knows about, and they want to try and meet that. Especially if they're developing a solution, then they know they've got a leg up, right? So.
This is great, and this is a really nice segue into now that we've established what HIPAA is doing, how it's evolving, including working with other federal agencies. Now, from a state level perspective, how they know HIPAA is in place, they know it's preemptive, but what can they do, particularly regarding that consumer health information piece that I know that Chase is going to address. So I'll move over to our next speaker. And okay, yeah.
Great. Yes, thank you, Tara. Again, everyone, hi, my name's Chase Millay. I'm an attorney here at KO in Denver. I have my roots in Arizona, though. I've got my Cardinal football back here. I started out my career at the Health Information Exchange in Arizona, primarily working on HIPAA and those kind of health information technology regulations. And then now I kind of more broadly integrate consumer privacy laws, state consumer privacy laws, as well as GDPR. And then, as Claudia mentioned, AI is everywhere. We're starting to see, we've got GDPR, or Europe rather, is regulating. We've got some various states kind of throwing some noodles at the wall to see what sticks there. And so working a lot in that space as well. So yeah, if we go to the next slide, Tara. So in terms of a practical resource, I'll put the plug in for this tracker. This is from the International Association of Privacy Professionals. I looked again, they updated it yesterday, nothing new, thankfully. But they really do a good job of keeping this up to date. And this is the current state in the United States of where we have privacy laws. So as you see, you may have heard about CCPA. That was the first in California in 2020. And then you may have also heard about Virginia and Colorado. Those were the kind of first three. And then now we see this just kind of enormous flood of bills coming through the various state legislatures and at various stages where even as soon as this summer, we'll see more. And then on the 1st of January 2026, we'll get a whole new tranche of state privacy laws. So next slide, please, Tara. So just as a general overview, most of the state privacy laws have some similarities, thankfully. So as a kind of looking at those definitions first, typically we're talking about these concepts of either personal data or personal information, which, we heard John kind of talk about individually identifiable health information. In these consumer contexts, it's really just any individually identifiable information. And so the definitions are very broad. It's not necessarily just name, email, things like that. It's anything that could be reasonably linked directly or indirectly with a particular individual or household. That's coming straight out of California's definition. So that includes kind of things we don't always think about as personal information. Things like your IP address, or other kind of other kind of identifiers that maybe aren't really, oh yes, I would have totally associated with that with Chase. But let's say you've got a company ID or some other type of ID, then that would be the personal information of the subject of that data. So that kind of moving then back up to the thresholds, before we kind of go into the other, we'll talk about these other concepts here. Before everyone's like, oh my gosh, do I have to comply with that? Luckily, each of these laws in the various states have thresholds of when they apply. So not every organization is subject to CCPA, or in Colorado, the Colorado Privacy Act. Typically, this comes down to how many individuals in a given state about whom your organization processes data. For example, in Colorado, it's 100,000 consumers in Colorado. In other states, it can be different. Delaware, you're talking about 35,000 individuals, obviously, because it's just a smaller state. Montana, I think, is also 35, but usually it's somewhere between 35,000 and 100,000 individuals. That will be the threshold in terms of whether or not that law applies to you, to your organization. California is unique in that there is a revenue threshold. So if you do business in California and you have revenue in excess of $25 million, by the way, the California AG clarified that $25 million does not need to be in California. So any revenue company-wide, and you do business in California, then you are also subject to the CCPA, California's Consumer Privacy Act. And then just the last note on the thresholds, if you are selling data, And we won't go into that in enormous detail, but selling is a term of art and also applies to, Matt, you'll see that definition below around targeted advertising or cross-context behavioral advertising. If you're using cookies and you're making that available to third parties, then there's a lower threshold. So you see the example there of Colorado, there's a threshold of 25,000 consumers. That would trigger the applicability requirements on your organization if you process that amount of data. Okay, so we talked about the definition of personal data or personal information. Those terms are used kind of interchangeably. And then we also talked about threshold of when that law would apply to your organization. The other kind of concepts to keep in mind are this concept of sensitive data. So here's again a definition coming straight from Colorado, and you see it's really kind of what we normally would think of as sensitive. So it's like data revealing race, mental or physical health diagnosis, sex life, citizenship. These kind of things that when we talk about like the yuck factor. Would you want that person? Would you be kind of grossed out if someone was collecting that information and you had no idea? So in most instances, and I think we'll talk about this on the next slide, an organization will need consent to process that type of data. And you know, there's those requirements. And then finally, the other kind of concept to understand are these concepts of sale and sharing. And so we won't go into too much detail on the delineation there, but suffice it to say is typically there are opt-in or opt-out requirements depending on the state for you to sell or share information for targeted advertising, right? Using those cookies and selling that to third parties. Final kind of conceptual note around these state laws and just looking, you know, knowing who our audience is today. Thankfully, we've got exceptions if the organization is subject to HIPAA, but of course they're not uniform. So in some instances, we have an entity level exemption or exception. And that's where if your organization is a covered entity, then that law does not apply to your organization writ large. In Colorado, by contrast, however, there's a data level exemption. So that law does not apply to protected health information, that set of information likely, you know, in your EMR. However, if you process other information, let's say you're the large health system in Colorado and you have all sorts of kind of community programs or whatever, and it's not health information, and you reach that 100,000 threshold, then the CPA, the Colorado Privacy Act, would apply to the processing of that information. So just something to keep in mind in terms of whether or not your organization may be exempt, and then in given states, that calculus might be different. Okay, next slide, please. So we talked about threshold, or we talked about kind of our defined terms. I'm realizing I should have pre-ordered there, but that's okay. And we talked about the threshold of when those state laws apply. And so let's go over right now these kind of basic requirements. What are we looking at in each of these laws? So thankfully, most of them, save for California, and I'm sure many of that, California is always unique. They're always special, something in California. Most of them are pretty much identical in the way they kind of work. Sometimes there's differences on thresholds, but most of the definitions and the threshold and things like that are uniform. And frankly, even California fits into most of these as well. So generally, there are concepts of data minimization. So coming from the HIPAA space, we know the concept of minimum necessary. It also applies here in most of these consumer laws, using reasonably necessary and proportionate amounts of information to achieve whatever purposes you collected that information. Additionally, similar to looking at, you know, HIPAA, like we receive a notice of privacy practices, these state laws require you as an organization to post a consumer notice of your privacy practices. And that's the privacy policy, right? We see them in the website footer of most websites we visit. That what you're seeing down there is the attempt to comply with these privacy policy requirements. Under most circumstances, an organization needs your consent to process sensitive data. So if you determine that your organization is subject to these laws and not exempt under a PHI exception or under the entity exception, let's say you have, for example, like an Apple Health app or something along those lines where you're really just having that consumer upload their health information and there's no covered entity involved or anything along those lines, to the extent that an organization is processing that health information, there are requirements in the states to get the specific consent. And just as an FYI, you know, That doesn't mean saying, oh, you agree to our, using the data in line with our privacy policy. The state AGs have made clear that that's got to be a kind of a specific consent to say, we're going to collect and process your health information for these purposes, and you need the individual to consent to that processing. And then finally, just disclosures around, as we talked about earlier, around sales and sales of information, and then sharing information for targeted advertising. So those are the notice requirements. Then we get into the consumer rights. Here's the kind of lists that we have, the list of various rights individuals may have if they're a resident of a particular state and the organization is subject to that applicable law. But it's largely very similar to what we talk about from a HIPAA perspective, right? Your right to know what information is about you, your right to access that information and have that organization send that, port that data to a third party at your request. Your right to correct the data, request correction, request deletion. And then we get into these kind of more unique concepts of opting out of sales and targeted advertising, limiting use of sensitive data. That's a California one. And then California also says you get to exercise all these rights without being discriminated against. And then finally, we've got security requirements that are usually not as robust as the HIPAA security rule. But again, I think they're trying to use those same concepts of those technical and organizational controls to protect that data. And then finally is contractual requirements. So if you are a controller of data, that means you're the organization who determines the means of processing of the data, then you have requirements similar to a covered entity to place restrictions on those sub-processors, or rather those processors of your information. So you would do that through what is called a data processing agreement. That is the analogy to a business associate agreement when we're in the consumer privacy space. And the various state laws will have details around what needs to be in that contract to make sure you limit what those processors can do with the individual's personal information. Okay, and then last slide, I think, for me. So we talked about these kind of general consumer privacy laws. A few states have said, well, what about consumer health data laws, consumer health information in particular? We know we talked about in some instances, states define health information or mental or physical health information as sensitive data. Well, these three states have defined, Washington, Nevada, and Connecticut have begun regulating in particular consumer health data. And so we really saw Washington lead the charge there. That is one to keep an eye on, especially for all the JDs on the call, because there is a private right of action and we've seen large cases come with Amazon involved, AWS involved, and it presents a very significant risk for an organization who has availed themselves in any way to Washington law. Long and short of what these are requiring, we've got specific, looking at that basic requirements paragraph, we've got specific notice requirements. So as you see organizations that may be collecting consumer health, you'll start to see these consumer health notices next to that privacy policy on the footer. And that's what they're trying to meet, is these requirements, particularly in Washington and Nevada, around posting notices. You need specific consent in order to process consumer health data. So it's similar to the sensitive data requirement, but it's specific here in related to the consumer health data. There's those various consumer rights, kind of similar to what we looked at on the prior page. Another unique thing in a lot of these, I think it's all three of them, are geofencing restrictions. So we heard John talk about online tracking data. We've already and we brought that up again, how like IP address can be personal information. What these states are regulating is a lot of times people will try to target individuals who go and visit healthcare providers and say, oh, do you want this service? Because I saw you go to a dialysis clinic and whatever. It's very sophisticated marketing strategies. What these states are saying is, no, you cannot, within I think, for example, Washington is like 1,700 feet of a organization that provides healthcare services. You cannot target in that space. And they call that a geofencing restriction. And so, again, something to keep in mind, if you've got an organization who's doing nationwide marketing in these various states, you're going to run into these types of restrictions. And then finally, again, in Washington, we've got that private right of action. Again, thankfully, we see similar types of exemptions here or exceptions for covered entity and PHI. But I put each of the three out here because note, they are not the same. Everything, right? Everyone does their own little differences here. So it's important to look and say, okay, in Washington, it's a information covered by a covered entity. In Nevada, it's an entity exception. In Connecticut, we go to a PHI. So it's all three of those have little minor differences in what that will actually mean in terms of what data will be subject to these requirements. So that's the overall there. I guess my take home would be this is very much a part of the law that is in flux. As I mentioned, I think, even a year ago, we've probably got half a dozen or more states who are online in the past year. Probably expect another half dozen in the next 6 months to a year to come online with privacy laws. There are a lot of similarities. We really work with our clients to try to kind of shoot from the middle and say, all right, here's one privacy policy. It meets all the various requirements, but there's so much specificity. So trying to really understand what state you're in and then digging into each of those requirements is unfortunately the necessity, and it's only going to get more complicated. So that's the state we are in now.
That was pretty phenomenal. I don't know if those on the call and also the co-panelists have been trying to dissect and dig through these different state privacy laws, but it really is remarkable, Chase, that you were able to put it into the 5 basic requirements. What are the common themes? How do they vary? So just my thanks to you for distilling the information in such a clear way. I think it was extremely helpful and not as overwhelming. The question I kind of stuck with me as you were going through this is that difference in whether it's a covered entity or it's the data. And I was wondering, given your thoughts on, how quickly this is a changing pace, like how many states are enacting state data privacy laws and how they're shifting. In Arizona, many of people on the call are based in Arizona. We do not have a state data privacy law. What are your two cents on, do you think states are shifting more in the regulating data or regulating covered entity approach?
Yeah, it's a great question. I would say they are looking more at the data approach and don't want the large hospital system to kind of get off the hook. If they're doing a lot of other activities that may involve consumer data, then the states, I think, are saying, look, then we're going to regulate you based upon that data. Sure, you may provide healthcare services as kind of one part of your business, but to the extent you've got a foundation and you're doing fundraising and all these other things, they don't want to just have this big swath of consumer data that is not regulated. I don't know if this is true. I was trying to look earlier. I think California is the only one with the full entity. I don't know if John or Claudia, you have thoughts on that. But I think California has the entity, right? Covered entity, you're good. You don't need to comply with CCPA. I think that's unique to California. In Colorado, for example, it's only with respect to PHI. And so again, if the other data you're processing amounts to those thresholds, then you would still be subject. And I think that is that is where most states are going.
Yeah, if I could just add to that. So yeah, in that sense, Chase, I think you're correct. They're definitely going more towards the data. So with the exemptions, it's interesting because it depends on which part of the law or which law you're really kind of looking at. Each state has its own data breach notification law, which also it's because HIPAA is part of HIPAA, right? The breach notification rule, but the states handle it with a separate set of laws. And even states that wouldn't exempt a HIPAA covered entity do the entity level exemption for the consumer privacy laws, the breach notification laws, they might. Right. So even though they're protecting the information and you still have to do all the opt-in, opt-out things, you might not have to tell anyone about a breach if you're complying with HIPAA. You'd only have to do it under the one set of laws and not on the other. And there are some differences regarding notice requirements and the ways to look at that. So
great point.
Yeah, excellent. Wonderful. Well, we'll now move this on to our third and last presenter for today's webinar. Let me share my screen again and introduce Claudia Stedman. So I already did sorry, 1 second here. Let me Here we go. Claudia, the group knows a little bit about you, and they've already heard from you in just in the response to our panel open discussion. But go ahead and tell us a bit more about yourself, and then I'll get into the rest of your slides as you direct me to.
Awesome. Thank you, Tara. Hi, everyone. I'm very happy to be a part of this panel today. My name is Claudia Stedman. I'm a healthcare attorney at Snell and Wilmer. I am still kind of in the healthcare regulatory and compliance like generalist category. I started practicing right at the height of COVID, which was what got me so interested in the telehealth space. And I do work on the provider and practice side, a lot of HIPAA compliance, False Claims Act, Stark, anti-kickback work. But we also do a lot of licensing work. And so that was a lot of the work when I first started was trying to understand all the cross-state licensing requirements and interjurisdictional compacts, and just sort of evolving telehealth landscape, because Arizona was pretty quickly during COVID one of the leading states with sort of expanding access to care for people via telehealth. And so it's been an interesting space. I think we keep sort of getting this false start with, are they going to extend the Medicare waivers? Are they not? I saw something today that suggested maybe they're getting pushed to September, but it's kind of still up in the air. So there's been sort of a lot of flux at the beginning of COVID, and things have kind of calmed down, but I think that telehealth is going to always be sort of in the conversation from this point forward, just because so many people started using it during COVID. And it's obviously applicable with all of the state privacy and data laws that are changing or coming online. So Tara, if you want to jump to that first slide, that'd be great. So at the risk of stating information that is abundantly obvious to everyone, I think it's important just to set the stage of what telehealth is, because people do have different definitions of it still. And so it includes audio only, video conferencing, store and forward imaging, and streaming media platforms. Different states have different laws on whether you can do audio only, or it has to be visual and audio. But a lot of those rules sort of became more lax during COVID, and they're still in play now, although that may change in a couple of weeks. But the traditional model of telehealth is often referred to as a hub and spoke model, where the patient receives care at one site, which is the spoke, and then they're receiving that care from a provider who's working at another site, which is the hub. And obviously it's kind of crazy that the beginning of COVID, I think, was like exactly 5 years ago, either today or yesterday. It seems like it was much shorter. I can't believe it's already been 5 years, but during that time when, social distancing requirements and those mandates were in place, HHS and CMS implemented a number of waivers so that patients could access care remotely. And we saw a lot of benefits from that, not only from a, public health standpoint of decreasing the spread of COVID, but also for rural and underserved communities, or traditionally underserved communities, being able to access care. And we saw a lot of that in the mental health space, particularly during COVID, which, I think while that time was really stressful for a lot of people, that was sort of one of the silver linings of the public health emergency, is that it sort of reshaped some of the public health landscape and demonstrated we could potentially access or get access to care for patient populations who didn't normally have it. And during this time, there also were a lot of robust changes and additions to interjurisdictional licensing compacts. So whether that was for physicians, there's SIPACT, there's the interjurisdictional nursing licensure compact. They really took off and enabled providers to obtain licensure in multiple states and provide care to patients in multiple geographic locations, which was a huge help for people who were maybe stuck in a state or were staying at home in a place with family, which is not where they typically resided. But it created a lot of confusion, at least initially, for providers of, how do I navigate this? Can I be providing care to someone in this other state? And so a lot of that was sort of in flux at the beginning. There's still issues with licensing, but I think for the most part, it's calmed down, at least from the beginning of the PHE. So we're moving in the right direction there. Tara, if you want to jump to the next slide, that'd be great. So there's a lot of risks, I think, to providing care via virtual models. I'm not going to spend a ton of time going into all of them because I want to get to the other questions we have today. But I think that these issues, the potential security and privacy risks, have sort of been at play since telehealth came online, so to speak. They're not necessarily new with respect to the changing like state privacy laws, but I think that as some of these states are enacting more robust data and privacy laws, it's important to remember that there are lots of cybersecurity threats that can be at play with telehealth, and privacy concerns that are not necessarily like a software concern, but more is the patient accessing the telehealth visit in a secure location? Are they accessing it on a personal device that other people have access to? Are you transmitting information in encrypted about the visit or during the visit in an encrypted way or in a secure way? And so I think that as some of these regulatory changes are happening with data and state privacy laws, it's going to remain important for providers and telehealth platforms to stay on top of all these regulatory changes and evaluate how they may or may not impact the provision of care through this model. And I think that some of the best practices for mitigating some of these risks have remained the same. The number one thing, as I just mentioned, is staying on top of the regulatory changes. And I mean, shameless plug here for everybody who's a JD. It's always a good idea to consult a regulatory or compliance attorney if you have questions about these issues. I think sometimes it's nice to gut check and just say, okay, we've got our bases covered, or hey, this specific issue is coming up. What can we do to kind of mitigate our exposure? But I also think that one of the best ways to get ahead of these problems is educating not only your patients, but also if you're a provider in a practice or a hospital, making sure you're regularly engaging in trainings on what are best practices for securing PHI and ePHI. And I think another way is to be evaluating your practice form. So we've talked about notice of privacy practices, informed consent, making sure you have a telehealth specific informed consent. And there's other forms that, are relevant to this as well that you should be evaluating and making sure you've got everything that needs to be in there. And then if you can just go to the next slide, that would be great. And so the last piece on this is, I think, kind of recognizing the evolving state and federal privacy rules that are becoming more robust and are somewhat changing. HHS in January of this year released a guidance document on best practices for telehealth platforms to safeguard PHI. And I think that while it's specifically kind of targeted at telehealth platforms, I think a lot of that advice is useful for providers and practices as well. And so I think that it's sort of this recognition that there are more of these cybersecurity threats out there. There are more of these changing regulations that practices and the technology providers need to be aware of. And I know that I think each of the panelists have touched on this, but I do see the use of AI in the healthcare space generally, both like in a brick and mortar modality and also in a virtual model, becoming more important. I've had conversations with clients more on the use of AI in the brick and mortar space, particularly with using like medical AI scribes or recording patient encounters. But I think, I know there's AI platforms you can plug in for Zoom calls and things like that where it records. So I think that those are starting to become issues that are going to come up in the telehealth space as well. And like we were talking about earlier, HIPAA and other laws have not totally caught up to that. There's starting to be more discussion around this space, which I think is important. But ultimately, on the provider side, you have to be really careful about how you're storing that information. whether you're putting it into the patient's medical record, making sure that you're actually reviewing it for accuracy if you are going to put it into the electronic health record, and documenting that the patient has specifically given consent for the use of these AI technologies. So I think we're going to see a lot more of that in this space, both virtually and in person. And I think that there's going to be more activity in this area as there's clear overlap with all of the state laws that are kind of evolving in this space. Tara, I think you're muted.
Of course, that had to happen. Yeah, thank you, everyone. I would like to just follow up with Claudia and the panel for one more question. So I'm gonna, before I stop sharing my slides, we do have an evaluation that Melanie will be forwarding to everyone to get your feedback on today's talk. If you have any questions that come out of that, or also would like your 1 hour CLE, that will be the time to do it. And we do have another event coming up on April 16th with the Arizona Telemedicine Council. Some of the issues that Claudia mentioned with the interjurisdictional compacts with licensing, and what's going to be, hopefully we'll have more clarity what's going on with the Medicare flexibilities being extended. We'll address that on the April 16th webinar. So please do join us if you're free. So with that, I'll stop sharing my slides. I can see all our wonderful panelists, and just my thanks to all of you for taking the time to do this, and for those of you who are also on the call. I just thought that was really great, Claudia, to remind us all that when COVID did happen about over 5 years ago now, and one of the biggest issues that I kept getting questioned about, and maybe you did as well from your clients, was HIPAA was relaxed in terms of enforcement during the PHE, and a lot of people got really used to using things like WhatsApp and Facebook Messenger to have their calls, and it was a big shock when they had to become HIPAA compliant somehow. So I just thought your advice at the end there of like very practical things to do in terms of storing the data, the informed consent, specifically for telehealth, specifically if they're going to use AI, was all really good information, because I think, there's also this like sensitive balance between providing access and also protecting patients' data. So I don't know if you want to elaborate on that anymore from a patient consumer perspective, because up to this point, we've been focused, pretty much on the provider or the platform. Please feel free to let us know.
Yeah, just a couple of things. I mean, I think from the patient side, like I mentioned, make sure if you're receiving telehealth services, like you're not in a Starbucks, you're not messaging your provider on SMS text message. That if you're using a computer, it's password protected, or it's, you're the only one using it. And I think those are sort of obvious but important ways that you can, as a patient, protect your own health information. I think there's more platforms that are online now using end-to-end encryption, making sure there's email platforms you can use now that are HIPAA compliant, and just sort of you have to, I think, be a little bit more aware that there are these bad actors out there, and health information is like the primo type of data that someone can get. So I think that it's sometimes easy when you're on Zoom or any other type of platform where you're interfacing with someone virtually to just shoot a text or shoot an email while you're in the meeting, and kind of forget that might not be the most secure way to transmit the information. So I think it is both people have to be vigilant and cognizant of what you're sending and how you're sending it.
It's an excellent point to end on. I so desperately want to do a round robin, but I think I'm going to let everybody go, and then maybe hopefully invite you back. Maybe to Chase's point, like at the end of the legislative session and end of June. But if you have any questions or remaining thoughts, let me know. If not, I just want to extend my gratitude and appreciation for all of you and for our panelists, for our sponsors, and for our audience. I hope everybody has a good week. Oh, maybe, I'm sorry, I'll turn it to Melanie. Go ahead.
No, that's all right. I was just saying, I was checking the chat and it doesn't look like there's any questions in the chat. And we actually have had some participants from the other parts of the world, particularly in Ghana. We had a gal with the National Health Insurance Authority with us today. So thank you and welcome. So yes, please, by all means, do the evaluation. It was dropped in the chat, but I will also be sending it in an email. And this has been recorded and that information will be in the email as well on how you can access that. Thank you everyone for joining us, and please come back and join us for another session in the future. Thanks, everyone.
Yeah, thanks, everyone.
Thank you all.
All right, bye.